Currently in Australia, 1 in 3 marriages are ending in divorce. As such, blended families with complex family structures, which include one or more stepchildren, are becoming increasingly common throughout. This has caused an increase in the number of stepchildren contesting wills. If a stepchild would like to contest a will, they have to file what is called a family provision claim to prove that they have not been adequately provided for. The rights of stepchildren vary slightly in each state. For example, in New South Wales, stepchildren are only eligible if they can prove that they were dependent on the step-parent who passed away and shared a residence with them at the time. In Western Australia, the laws are more complex. A stepchild must have been wholly or partly maintained by the step-parent immediately before the deceased's death, or the deceased must have received or have been entitled to receive property from the parent of the stepchild to a value greater than $460,000. Hentys is a Melbourne-based law firm that deals with cases throughout Victoria. As such, we'll provide more information on the laws around stepchildren contesting a will in this state. In Victoria, a stepchild and a child are both treated in the same way for the purpose of contesting a will. The two main questions we are asked when it comes to stepchildren contesting wills are whether the natural parent and their new partner have to be married for the new partner to be considered a step-parent, and whether the child is still considered the step-parent's stepchild on the death of the natural parent. The very recent Victorian case of Bale v Scott Mackenzie demonstrates both of these questions in operation. In this case, the applicant's mother was a domestic partner of the deceased for 40 years prior to her death 15 years ago. However, they weren't married. The deceased's will did not provide for the applicant, who argued that stepchild, under the Administration and Probate Act, should be given a wide meaning to include the children of domestic partners, and that her status as a stepchild does not end when the natural parent dies. She argued that as a result she should be considered the stepchild of the deceased and an eligible person to whom the deceased failed to make adequate provision. The court determined in favour of the applicant, stating that a stepchild includes the child of a domestic partner as well as a child whose natural parent dies before the remaining step-parent. This case demonstrates the law's changing perspective on domestic partnerships and blended families. It's clear that the definition of stepchild now includes the child of a deceased's domestic partner, and that the death of a natural parent will not stop a stepchild from disputing a will, so long as the relationship was undissolved at the time of the death of the natural parent. For more information regarding the definition of a stepchild, or if you think you have a right to dispute a will, please don't hesitate to contact the team at Hentys Lawyers.